Hi again, we're back. So this is just part 2 of the first week of the Human Rights Tribunal content to help set you up for your human rights advocacy assignments, part A1. Just jumping in here at the PowerPoint slides 6, 7, 8, specifically that talk about the distinctions between the Tribunal, the Commission, and the Human Rights Legal Support Center. So these three parties came to coexist in 2008 when there were some changes made to the human rights system in Ontario. Prior to that time, there was a tribunal under a previous name, the Board of Inquiry, of course. There was the Commission. They've existed since 1958. It's the Human Rights Legal Support Center that we see at this time. That is the new sort of kid on the block, okay? The new person in the relationship to create better support for individuals who have applications before the tribunal, essentially. So that all starts in 2008. So the tribunal then exists from that time. The tribunal as we know it, the HRTO, they are empowered through the code, as I previously mentioned to you in the other video, under the Human Rights Code of Ontario. And the Human Rights Tribunal of Ontario actually belongs to the Social Justice Tribunals Ontario cluster. So we have talked about the SJTO cluster previously this semester, specifically how it houses within its sort of umbrella cluster the Social Benefits Tribunal and the Landlord and Tenant Board. So the Human Rights Tribunal of Ontario is also part of that cluster. We have the Commission as well, and they've existed for some time. The Commission plays a unique role here. They help develop policy, they do public education, they often act as an intervener in matters before the Human Rights Tribunal. So what's an intervener? That word has also popped up different times this semester and last semester. And an intervener is essentially a public interest body who is allowed to provide submissions to the court. They don't play a full role that other parties do, like the applicant or the respondent. They can provide written submissions, and then the tribunal might consider those written submissions as they're making a determination. So I previously mentioned to you, I believe, MAD, Mothers Against Drunk Driving, and a couple of others. Some of them you have been familiar with from your Charter of Rights assignments that you completed last semester. So the Commission often acts as an intervener. They are also informed of all applications that go before the tribunal, and they receive copies of the applications and responses. And this is so that they are aware of what the tribunal is dealing with. They can apply to be an intervener if that is a case that has broad public interest. And also this helps, to a certain extent, develop their policy, inform their policy, because they can see what matters perhaps are, turning up again and again as a regular discrimination before the tribunal. All right, and then we have the Legal Support Center. And the Legal Support Center, that's the piece of the puzzle that sort of was new in 2008. The Legal Support Center largely, they act almost like a legal aid clinic would act. They're staffed with paralegals and lawyers, in this case, pretty much experts in the human rights field. And they can help applicants with their applications. They can provide some summary advice up front. They don't often represent, though they may represent, okay? And typically they would choose to represent in cases where obviously the applicant doesn't already have a representative, and there's a huge public interest element, okay, to that case. So those are those three parties. So just a couple of other things then we'll get into before we move to the next video, because this is going to have to be done in portions just because of size. Code grounds of discrimination then. There's a number. You'll find these outlined at slide 9, and in your textbook, the definitions for each appear on a number of different pages. So pages 30, 31, 33, and 35 of your textbook will provide sort of broader definitions of what each of these code grounds of discrimination are, right? So race, color, ancestry, place of origin, citizenship, ethnic origin, family status, marital status, age, creed, sex, which includes categories of sexual harassment, if you are discriminated against for pregnancy or breastfeeding, okay? All of that would fall under the category of sex in an application. Sexual orientation is another ground, a separate ground from sex. Gender identity and gender expression, those are the two newer grounds added in 2017. receipt of public assistance in the area of housing specifically, and also a record of offenses in employment and criminal convictions for which a person has received a pardon. So I just wanted to clarify a couple of those with you. One of them, family status, that refers to being in a parent and child relationship. So that doesn't have to be a biological parent or even an adopted parent, with all the proper sort of adoption papers and stuff that might come with that relationship. That can be even a grandparent or aunt and uncle with a child, however that parent-child relationship is for that specific child, essentially, okay? Any discrimination on those grounds can be linked to family status on your human rights application. And marital status refers to being married, being single, widowed, divorced, separated, also living in a conjugal relationship outside of marriage, and it also includes same-sex marriage as well. The 5 code social areas, just as a refresher, I mentioned those at the start of the last video for this topic. Accommodation in housing, that's found at section 2. Contracts, so protection from discrimination in written, oral, or signed, meaning sign language contracts, not signed contracts, okay? And in all types of contracts that might arise, whether that be housing or business or however the contract might be, whatever it might be linked to. Social area of employment, so you cannot be discriminated against in getting or keeping a job, a promotion, a raise, any of those, and it even applies to the working conditions within a workplace. Then we have the code social area of services and facilities, which is found in section 1 of the code. So this refers to when you're buying a product or a service or using a building or a facility that is public, okay? And then membership in unions, trades, professional associations. So the membership, the right to be to equal treatment and equal membership in any of those professional associations, again, like the Law Society of Ontario. And I only give you that example because that's the realm that we work in. Of course, we would hope and expect and can trust that the Law Society would protect against discrimination by its members or toward its members. So just to be clear, the last slide, a minute ago, I read to you the grounds of discrimination under the code, and now I've just told you the 5 social areas. So to file an application before the tribunal, you need to have a link between both. You need to have a nexus. So you need to have one of the code grounds covered as well as one of the code social areas. So the discrimination had to have been on one of those grounds, like race or age or creed, or sex, linked to a social area. So in contract, in employment, in housing, in receiving a goods or a service. So you have to have a code ground as well as a code social area, and they have to be linked together, essentially, and you have to identify both on your application before you proceed. So some definitions then under the Human Rights Code or in the area of human rights that might arise. Discrimination, this comes from your textbook at page 30. Discrimination is essentially subjecting another person to differential treatment by either imposing a burden on them or denying them a privilege, benefit, or opportunity that are enjoyed by others because of their characteristics. Discrimination. Harassment then, which is also covered by the code, so harassment in any one of those grounds as well is prohibited. You can find this definition at your textbook, page 30 as well. Harassment is engaging in a course of comments or actions that are known or ought reasonably to be known to be unwelcome. It can involve words or actions that are unknown or should be known to be offensive, embarrassing, humiliating, demeaning, or unwelcome. So that's harassment. That's covered by the code. Reprisal. What is reprisal? We talked about reprisal under the Ontario Labour Relations Board content as well. And it's essentially being punished for enforcing your rights. So if you claim that you're being discriminated against in your workplace, either by another employee or by the employer, if you go to your employer about that and you start to receive negative treatment as a result, so essentially you're being punished or mistreated because you tried to assert your rights, that's reprisal. And you cannot face reprisal under the code. So that's prohibited as well. Exemption we're going to come to momentarily. But an exemption is found in your textbook at page 36, and it essentially, the quote from your textbook is, when an individual is not bound to fulfill an obligation or a requirement that others must observe under the code. So we'll talk about what those exemptions are shortly. And then, of course, association. You also cannot be discriminated against on the grounds of association. So essentially being associated with a group that's protected under the code. Association being defined as being discriminated against or harassed because of the company that you keep. For example, if your partner is a particular race or color and then you're denied housing on that basis, that would be discrimination on the grounds of on the grounds of race, but linked to the association aspect. So we're going to pause this video now again, and we're going to jump back in momentarily to the exemptions and then into the rest of the content for the first part of the Human Rights Tribunal lecture. Talk to you soon.